What happens in mediation? Hey there, my name is Ron Payne. I'm the CEO and managing partner here at Payne Law in Kernersville, North Carolina, where we help families navigate life's important decisions. And if you're going through a court process, particularly for equitable distribution or alimony spousal support, it is highly likely you're going to go through mediation. Also, if you're going through child custody, child support, you may go to mediation as well. Now, child custody mediation, the mandatory one ordered by the court, is a little bit different of a process. So what I'm talking about today is what happens if you're going through private mediation. And then I'll do a separate video for you in terms of what happens if you go through court-ordered child custody mediation. So if you're doing private mediation, whether that's for alimony, spousal support, or equitable distribution, and it's mandatory in cases of equitable distribution, it's not mandatory for spousal support or alimony, then you're going to first, usually there's going to be an exchange of documents between the attorneys, the affidavits showing kind of what we think all the property is, what we agree is, what I think is my separate property versus what you think is your separate property, and that sort of thing. And then what we agree is marital property, making sure we really list all the property. Because sometimes, you're thinking about maybe the couches, the furniture, and the retirement accounts. And the other spouse might be thinking of the tools, gun collections, the more tangible stuff in the house. What we want to do is make sure that we kind of get everything on the table. And so we'll send our list, they'll send their list of stuff over, and we'll exchange those documents so we can kind of just make sure we're all on the same page. Next thing you're going to do is pick a mediator. Now, we almost exclusively work with experienced family law mediators who are also family law attorneys. That's not required by the law, but in our experience, working with an experienced family law attorney who's also a mediator, preferably one who has an extensive knowledge of how our local judges tend to handle matters, can be helpful, because then not only do they know the law and they can help you make good decisions in terms of trying to settle your case, but they can also give good advice, if the attorneys want, regarding how they think the local judges are going to adjudicate your claims. If you know what the outcome is going to be, and you know a judge is going to do X or Y, then oftentimes it might make more sense to settle your case rather than spending $10,000 more on legal fees to go get there. But if you're working with a mediator who doesn't have that experience, then that doesn't carry any weight, and it doesn't necessarily help push something towards settlement. In almost all cases, settling your case in mediation is going to be more cost advantageous, it's going to be quicker, it's going to be less painful, and it's going to help you move on to better days and greener pastures ahead. So you're going to pick a mediator. Usually the clients ask us, well, who would you pick? Who do you recommend? And we'll come up with one or two names. If you are working with if there's an attorney on the other side, they too will pick a couple of attorneys, and we'll try to reach an agreement based on who we think should be used. If we can't reach an agreement, then we can ask a judge to assign us a mediator to help us resolve our differences. More often than not, good attorneys are going to agree to good mediators. And that's why we try to use the best mediators possible for the case that's in front of us. Not all mediators have the same skill sets. Some are better at high asset cases. Some are better at lower asset cases. Some are better at matters involving children. Some are better at matters that don't involve children. And those are all things that we're going to take into account. So once you've got your mediator picked, then the next thing is you're going to go to mediation. And so when you exchange your information and you get started, the first thing that's going to happen is the mediator is going to walk in the room, and they're going to give each of you, well, first off, let me back up. The first thing that's going to happen is, for family law mediations, you're not going to be in the same room almost ever. We know as experienced attorneys that usually just results in getting everything off to a worse start. So if it's amicable, then maybe we'll start in the same room, but usually we don't. And so the mediator is going to go into each room, our room, their room, and they're going to explain to each of you the exact same speech. And that speech is going to consist of, this is what's required for me to tell you under mediation. This is what the process today is going to look like. This is what you can expect from a cost standpoint. These are the things I'm required as a mediator to keep secret. These are the things as a mediator I'm required to tell the other side. These are the things as a mediator I'm going to tell the other side unless you ask me to keep them secret. And those kind of procedural things. And they're going to give that procedural, how it kind of going to go today speech to each room. And that's where you might start together. If everything's amicable, they'll give you that speech at the outset so that you can both hear it once, and it kind of saves 30 minutes to an hour. Once they've given the speech, as I like to call it, then the next thing that's going to happen is they're going to start with the initiating party. So whoever kicked this off today, they're going to start with them and they're going to ask, what do you want today? What do you want to happen? What are your goals? If you're working with the team at Payne Law, we're going to have this conversation in advance so that we can effectively advocate on your behalf to prepare you for mediation. It is my experience, unfortunately, that some attorneys don't prepare for that, and so they kind of come in and they just ask for everything under the sun. If I've learned one thing for certain, it's that the first round of offers in a mediation is going to just piss everybody off. You just need to know that going in, because we're going to ask for what we want under the sun. They're going to ask for everything that they want under the sun. If we've been exchanging offers back and forth, oftentimes the other side's first mediation offer is going to be the harshest one, even if we've already kind of negotiated down. Sometimes you'll pick up where you left off, or if we were at you getting half and them getting half and they really want 40, 50, 40, 60, they might come in offering 48, 42, 58 split percentage-wise, right? But oftentimes people are going to start with they're like, I want everything and they get nothing. Not productive, but that's oftentimes how it goes. They throw all their mud at the wall at the first thing. So you just need to know that. So that first hour of mediation is really just kind of establishing what goes back and forth. So if you start mediation at 10 o'clock, I just want you to know it's probably going to be noon before you really get into brass tacks. And that's why when you say, well, I think we could solve this in 3 hours. The problem is it's going to take an hour to go over the pleasantries and the requirements under the law that a mediator has to give you, the speech that's part of, set forth by state law and required, about how mediation works and what your choices are and who's in charge and who makes the decisions. It might be noon before you really start to make any progress on the issues. But you have to work through those where everybody is before you can work to where you want to get to. But that's why it's so important that your attorney and the mediator kind of know, this is my real goal. This is kind of what I'm willing to settle for. And if they want to do this, I'm not willing to do that. Because if the mediator knows best case, acceptable worst case, and like the unacceptables, like for example, if the other side is, I want the dog, and you're like, I own the dog prior to marriage, you're not getting it, then the mediator needs to know up front, hey, this is an issue of contention. Here's the surrounding facts. It was my dog prior to marriage. They can't have it. But it's just helpful to know those things. So mediation usually takes between 6 to 8 hours. But what's going to happen then is after we have that first round and everybody's pissed off, we give everybody a chance. All right, calm down. We knew it was going to be an angry offer. We knew they were going to ask for everything. Don't let it get in the way of a true resolution. The next thing we're going to do is try to make incremental steps. What can we give up that we don't care as much about in order to get the things that we really want to get? Mediator is going to talk to you. You'll talk through both sides. At the end of that session with the mediator, again, they're not in the room. This is just you, your attorney, and the mediator. And you come up with an offer that you like, then fantastic. You send the offer over. And as part of that offer, you tell the mediator what they can discuss, what they can offer, and you tell them the things that they can offer if they need to, but you kind of want to hold back. And then you tell them, these are the things I don't want you to divulge just yet. And there might be things you don't divulge to the other side at all, especially if you think they're not going to agree and you think you're going to go to a court hearing. Then you're not going to divulge everything because it's not time to put it out there at this time. The point of mediation is to get to resolution. So you give as much as you need to get resolution, or you lay all your cards out there so that they look, you can go to court, but this is what the laws is. This is what the judge is going to do. Let's move forward. And the mediator is going to take your offer, go to the other side, work through the issues, counter your offer almost always. And so you'll go back and forth with offers, details, and facts back and forth. Usually it takes anywhere from the first time can take hour or even 2 hours. And while the mediator is in the other room working through issues, you're just over here waiting. A tip for mediation that I give all my clients, bring a book, bring a Kindle, bring a laptop. You might be able to get some work done because once the mediator gets your side of the story, they're going to go talk to the other side and they're going to give them that spiel and they're going to get their side of the story. And that's going to take an hour, especially if they're angry, right? So come prepared to spend lots of downtime between offers. And come prepared with knowledge of what's most important to you. Try to ferret out things as what's most important. What's important, I really would like it, but if I had to give it up, if I had to, I would. These are the things I don't really care about. And then these are the things that, like, if you want to go there, we're done here. Have a nice day. At the end of the day, huzzah, one of two things is going to happen. I guess I should say three. One, you reach an agreement. If you reach an agreement, the mediator will help your attorneys write it up. If there are no attorneys involved in the mediation, it's a true pro se, the mediator can help write it up, and you're going to get an agreement. It's going to be bullet points. It's going to be short. It's not going to be a full-length, full-term agreement. It's just going to try to be to commemorate the points that were important and reached in mediation today. If you've got attorneys, they're going to draft up a similar bullet point agreement, and then they'll go back to their offices and draft a full agreement. If you knew coming in you were going to get a full agreement, or there was a pretty strong chance that it was going to happen, especially if you started to get into it, then maybe the attorneys will start drafting the full agreement while you hammer out the finer points back and forth. But either way, you're going to leave with an agreement, temporary or full, depending on what you're able to draft, but you're going to leave with a written agreement. If you're able to reach a partial agreement, or that's okay too, you'll just put what you do agree to in writing, and you'll either come back for a subsequent mediation if you think, you know what, we just need to get some more information. We really need those bank statements. You weren't able to get them before the mediation. No problem, but we can't agree until we have the information in front of us. So let's go get those bank statements. We'll come back together in 60 days. Or we'll reschedule once we get that information from each other. No problem. So the second option is you come back for a subsequent mediation. The third option is you declare an impasse. We weren't able to reach an agreement. We're not going to be able to reach an agreement. And the only thing to do next is go to court. Good attorneys can settle almost all cases or substantially whittle down the issues. Let's get the stuff we agree on in writing, and then the stuff that we don't agree on in writing, we'll take to a judge. Now, sometimes you can't do that because maybe the stuff that you've agreed on is kind of contingent on that one big issue. Maybe it's the house, maybe it's the retirement accounts, and you can't agree on that. That's okay. You can go litigate that one specific issue. You can ask a judge to give a limited hearing just on these issues, or to hear testimony and to issue a partial order on those smaller issues, or maybe they're big issues. And then that will give you what you need to go back to the mediation table voluntarily and try to hammer out the rest of it. And then at the end of it, whether you've reached a temporary, like a partial agreement or a full agreement, that's going to be, if it's not fully executed and signed and everything done, you'll sign the bullet point agreement, but maybe you need to write all that out, especially if it's about custody or if there's complex assets splitting and you need to go get and all that, incorporate all that into the court order. Not a problem. You'll go back to each other's offices over the next few weeks. You'll draft that. You'll circulate drafts back and forth. Once the language is to everybody's approval, you go to your attorney's office, come into our office, sign the agreement, and you're finished. So we'll finalize that by either setting that subsequent hearing, or we will get everything in writing and put a bow on it. And then congratulations, you're done. Again, mediation is successful in 99% of cases if you've got good attorneys on both sides. The key there is both sides. If one side is unwilling or unable to negotiate, whether it's the other side, the other party, or if it's the other attorney, and some attorneys just want to go to court and try cases. They don't want to settle cases. They want to go to court. They want to have a trial because they like trial. Understand that, and maybe not what's best for clients, but if that's what you're facing on the other side, then we won't be able to reach an agreement. But most of the time, there's a reason you hear the old adage, 99% of court cases settle by the time they get to the courthouse steps. Because litigation is expensive, it can and will chew up a lot of assets in the process. And if you're the advantaged party, depending on what you're resolving, alimony, child support, spousal support, you could get on the hook for all of their attorney's fees. So it may not be advantageous to take it all the way to court. Sometimes you got to, and that's okay too. If the team at Payne Law can help you, whether you're looking at going through mediation or you need an aggressive advocate in your corner for mediation because they're not going to be agreeable unless you've got a fighter in your corner, because they need to know that if you don't settle, you are going to court and you will take it all the way, the team here at Payne Law can help. We've been handling family law matters for over 12 years. We've got a great team, and we will take great care of you and communicate with you throughout the entire process to help make sure that your family is protected. If you'd like to set up a low-cost consultation with our family law team, you can reach us on the web at applepainelaw.com or give us a call at 336-281-6928. I hope this overview of mediation has been helpful. Like and subscribe here on YouTube for more helpful and friendly legal content. And until next time, take care and have a great day.